Dear learners, welcome to this course on gender sensitization, society, culture and change. Today we will be discussing on implementation of laws to Prevention of Domestic Violence Act 2005 Part A. It is very important that when we talk about this legislation, we cannot say that we will be talking about the entire legislation because you are not from the law background. So we are discussing the important provisions of this act so that you are aware about this legislation, and in case of need and for awareness you know the provisions of this act. The name of this legislation is the Protection of Women from Domestic Violence Act 2005. Every legislation comes up with an objective. So what is the objective of this act? An act to provide for more effective protection of the rights of women guaranteed under the Constitution who are victims of violence of any kind occurring within the family and for matters connected therewith or incidental thereto. A very important objective, So this legislation is for women. Certain rights have been guaranteed under the Constitution of India. So this act ensures that the rights which are there in the Constitution of India are available to the women of this country who are the victim of violence of any kind within the family or matters connected therewith or incidental thereto. This act extends to the whole of India. And when we talk about the definition, section 2 talks about the definition part. We will only discuss the very important definitions, and 2A talks about aggrieved person. Who is an aggrieved person under this legislation? Aggrieved person means any woman who is or has been in a domestic relationship with the respondent and who alleges to have been subjected to any act of domestic violence by the respondent. So very important definition. So any woman who is or has been in a domestic relationship with the respondent and has been subjected to violence is an aggrieved person under this legislation. Child means any person below the age of 18 years and includes any adopted step or foster child. So when we see the definition under section 2B, it is not that the child which is adopted will not be included in this, a step child will not be included in this, or a foster child will be differentiated. Child is a child whether he is an adopted child, a step or a foster child, or your own child. So any child below the age of 18 years is a child under this legislation. 2C talks about the compensation order, which means an order granted in terms of section 22. Custody order has been defined in section 2D, which means an order granted in terms of section 21. 2E talks about domestic incident report, a very important definition, means a report made in the prescribed form on the receipt of a complaint of domestic violence from an aggrieved person. So domestic incident report is prepared by the service provider or the protection officer. Domestic relationship has been defined in section 2F, means a relationship between two persons who live or have at any point of time live together in a shared household. So it is not important that you have to be living in that shared household or in that domestic relationship. Either you are living there or you have lived at any point of time, and you can file a complaint later on also for domestic violence cases. When they are related by consanguinity, that means that descended from the same ancestor, marriage or through a relationship in the nature of marriage, adoption, or are family members living together as a joint family. So it is not available only to the married woman. It is also available to any woman, any girl in the family. 2G talks about domestic violence. Domestic violence has the same meaning as assigned to it in section 3, and we will be discussing about this definition in detail after some time. Medical facility has been defined in section 2J, means such facility as may be notified by the state government to be a medical facility for the purposes of this act. 2K talks about monetary relief. Monetary relief means the compensation which the magistrate may order the respondent to pay to the aggrieved person at any stage during the hearing of an application seeking any relief under this act, to meet the expenses incurred and the losses suffered by the aggrieved person as a result of the domestic violence. 2N talks about the protection officer, means an officer appointed by the state government under subsection 1 of section 8. Protection order is defined in 2O, means an order made in terms of section 18. 2P talks about residence order, means an order granted in terms of subsection 1 of section 19. 2Q respondent means any adult male person who is or has been in a domestic relationship with the aggrieved person and against whom the aggrieved person has sought any relief under this act. So the accused, the person who has been engaged in domestic violence or who has committed domestic violence is a respondent, and he should be a male adult. It is not important that only husbands are respondent. It can be your any male partner, it can be your father, it can be your brother, he can be anybody. Provided that an aggrieved wife or female living in a relationship in the nature of marriage may also file a complaint against a relative of the husband or the male partner. So, along with the husband or the male partner, you can also file a complaint against the relatives. 2R talks about service provider, means an entity registered under subsection 1 of section 10. 2S, very important definition of shared household. What is a shared household? Because when people come to us and ask, they have no idea about the concept of shared household. Shared household means a household where the person aggrieved lives or at any stage has lived in a domestic relationship, either singly or along with the respondent. So even if you have lived there alone or along with the respondent, still that is a shared household. So that household, whether owned or tenanted, either jointly or by the aggrieved person and the respondent, or owned or tenanted by either of them, in respect of which either the aggrieved person or the respondent or both jointly or singly have any right, title, interest or equity, and includes such a household which may belong to the joint family of which the respondent is a member, irrespective of whether the respondent or the aggrieved person has any right, title or interest in the shared household. So it can be a government accommodation, it can be an accommodation by a private organization, it can be your own house, it can be a joint family owned house, it can be your in-laws house. So either you own it, you are a tenant in that house, it does not matter. Whether you have some rights in that property or you don't have rights in that property, it does not matter. The main concern is that you must have lived there. You must have lived there or you are living there in a domestic relationship. Shelter home is defined in 2T. Any shelter home as may be notified by the state government to be a shelter home for the purposes of this act. Now we will discuss about the domestic violence definition that is given in section 3 of this legislation. For the purpose of this act, any act, omission or commission or conduct of the respondent shall constitute domestic violence in case it. So let me explain this. Any act, you do something, you do not do something, omission, or you commit something, or the conduct of the respondent shall constitute domestic violence if it harms or injures or endangers the health, safety, life, limb, or well-being, whether mental or physical, of the aggrieved person or tends to do so, and includes causing physical abuse, sexual abuse, verbal and emotional abuse, and economic abuse. So all these kinds of abuses are covered. It can be physical, sexual, verbal, emotional, economic. Harasses, harms, injures, or endangers the aggrieved person with a view to coerce her, to force her, or any other person related to her to meet any unlawful demand for any dowry or other property or valuable security. So if I do not feed your child and tell you that if you do not follow my instructions, unlawful instructions, then I will harm your child or your brother or your mother. So if you are coercing me, if you are forcing me to do something which is illegal, then this is an act of domestic violence. Has the effect of threatening the aggrieved person or any person related to her by any conduct mentioned in clause A or clause B, or otherwise injures or causes harm, whether physical or mental, to the aggrieved person. Physical abuse means an act or conduct which is of the nature as to cause bodily pain, harm, danger to life, limb or health, or impair the health or development of the aggrieved person, and includes assault, criminal intimidation and criminal force. So you cannot use force on me, you cannot intimidate me, you cannot use assault on me. Sexual abuse includes any conduct of a sexual nature that abuses, humiliates, degrades, or otherwise violates the dignity of the woman. So dignity has been ensured under Article 21 of the Constitution of India, and dignity has to be maintained in all circumstances. So in all circumstances, you cannot say that you can outrage the dignity of a woman. Verbal and emotional abuse includes insults, ridicule, humiliation, name calling, and insults or ridicule, especially with regard to not having a child or a male child, and repeated threats to cause physical pain to any person in whom the aggrieved person is interested. Economic abuse includes deprivation of all or any economic or financial resources to which the aggrieved person is entitled under any law or custom, whether payable under an order of the court or otherwise, or which the aggrieved person requires out of necessity, including but not limited to household necessities for the aggrieved person and her children, if any Sridhan property joint or separately owned by the aggrieved person, payment of rental related to the shared household, and maintenance. So economic abuse can vary from case to case. If you are not letting me, meet out my daily expenses of medicine, it is an economic abuse. Then if you are not able to sustain your family and you have a valid reason, that is a different case. But if you malafidely, do certain act in which you try to harm the family, it will be coming under this law. Disposal of household effects, any alienation of assets, whether movable or property, movable or immovable property, valuables, shares, securities, bonds, and the like, or other property in which the aggrieved person has an interest or is entitled to use by virtue of domestic relationship, or which may be reasonably required by the aggrieved person or her children or her Sridhan, or any other property jointly or separately held by the aggrieved person. So you cannot dispose of the property, or it can be a movable, immovable property, my Sridhan, just to harass me. Prohibition or restriction to continued access to resources or facilities which the aggrieved person is entitled to use, or enjoy by virtue of the domestic relationship, including access to the shared household. For the purpose of determining whether any act, omission, commission or conduct of the respondent constitutes domestic violence under this section, the overall facts and circumstances of the case shall be taken into consideration, a very important explanation. Now we will be discussing section 4, which talks about powers and duties of protection officers, service providers. Information to protection officer and exclusion of liability of the informant. Any person who has reason to believe that an act of domestic violence has been or is being or is likely to be committed. So even if it is likely to be committed, may give information about it to the concerned protection officer. No liability, civil or criminal, shall be incurred by any person for giving in good faith information for the purposes of subsection 1. So if you are acting in good faith, you will be protected by the law. Section 5 talks about duties of police officer, service provider and magistrate. A police officer, protection officer, service provider or magistrate who has received a complaint of domestic violence or is otherwise present at the place of an incident of domestic violence or when the incident of domestic violence is reported to him shall inform the aggrieved person of her right to make an application for obtaining a relief by way of a protection order, monetary relief, custody order, residence order, compensation order or more than any such order under this act. So very important provision for the benefit of the woman or for the benefit of the victim, You can write an application for obtaining relief. It can be to protect you, for any kind of monetary relief. If you want a custody order, you can just request. If you want a residence order, you can request. For a compensation order, you can request. Of the availability of services of the service provider, also they are duty bound to tell you. So these are your rights, you should know about this. So the protection officer will tell you about these rights. Of the availability of services of the protection officer, of her right to free legal services under the Legal Service Authority Act, of her right to file a complaint under section 498 of the Indian Penal Code wherever relevant, provided that nothing in this act shall be construed in any manner as to relieve a police officer from his duty to proceed in accordance with law upon receipt of information as to the commission of a cognizable offence. So for serious offences, a police officer can proceed further also under the IPC provisions. Duties of shelter homes. Section 6 talks about duties of shelter homes. If an aggrieved person or on her behalf a protection officer or a service provider requests the person in charge of a shelter home to provide shelter to her, such person in charge of the shelter home shall provide shelter to the aggrieved person in the shelter home. Then duties of medical facilities are mentioned in section 7. If an aggrieved person or on her behalf a protection officer or a service provider requests the person in charge of a medical facility to provide any medical aid to her, such person in charge of the medical facility shall provide medical aid to the aggrieved person in the medical facility. Section 8 talks about appointment of protection officer. The state government shall by notification appoint such number of protection officer in each district as it may consider necessary, and shall also notify the area or areas within which a protection officer shall exercise the powers and perform their duties conferred on him by or under the Act. So, while appointing the protection officer, they will also define their powers, functions and their roles and their area. The protection officer shall as far as possible be woman and shall possess such qualification and experience as may be prescribed. The terms and condition of service of the protection officer and other officers subordinate to him shall be such as may be prescribed by the law. Duties and function of protection officer, it shall be the duty of the protection officer. So now we are talking about the duties and functions of protection officer. To assist the magistrate in the discharge of his function under this act, to make a domestic incident report. So the protection officer has to make the domestic incident report and submit it to the magistrate in such form as in such manner as may be prescribed upon receipt of a complaint of domestic violence, and forward copies thereof to the police officer in charge of the police station within the local limits of whose jurisdiction the domestic violence incident has occurred. For the safety of the woman, for the protection of the woman, it is very important that this report is shared with the police officer in charge, and then the police officer in charge and the service provider of that area will do their respective duties. To make an application in such form as in such manner as may be prescribed to the magistrate if the aggrieved person so desires, claiming relief for issuance of a protection order, to ensure that the aggrieved person is provided legal aid, and make available free of cost the prescribed form in which a complaint is to be made to the victim. To maintain a list of all service providers providing legal aid or counseling, shelter homes and medical facilities in the local area within the jurisdiction of the magistrate, so that if any woman, any victim wants any kind of help, that can be immediately provided to that woman. To make available a safe shelter home if the aggrieved person so requires, and forward a copy of his report of having lodged the aggrieved person in a shelter home to the police station and the magistrate having jurisdiction in the area where the shelter home is situated, so that the police officer can ensure that the woman is safe in the shelter home, and the magistrate is also aware about her stay. To get the aggrieved person medically examined if she has sustained bodily injuries, and forward a copy of the medical report to the police station and the magistrate having jurisdiction in the area where the domestic violence is alleged to have been taken place. To ensure that the order for monetary relief under section 20 is complied with and executed in accordance with the procedure prescribed under the CRPC. To perform such other duties as may be prescribed, the protection officer shall be under the control and supervision of the magistrate and shall perform the duties imposed on him by the magistrate and the government. Service provider, subject to such rules as may be made in this behalf, any voluntary association registered under Societies Registration Act, or any company registered under the Companies Act, or any other law for the time being in force with the objective of protecting the rights and interests of women by any lawful means, including providing of legal aid, medical, financial and other assistance, shall register itself with the state government as a service provider for the purposes of this act. So any society or any company which has an objective of protecting the rights and interests of women, or they provide legal aid, medical or financial or other assistance to the women, they can register themselves as service provider. A service provider registered under subsection 1 shall have the power to record the domestic incident report in the prescribed form if the aggrieved person so desires, and forward a copy thereof to the magistrate and the protection officer having jurisdiction in the area where the domestic violence took place. So either the service provider can record the domestic incident report, or the protection officer can record the domestic incident report and report it to the magistrate. Get the aggrieved person medically examined and forward a copy of the medical report to the protection officer and the police station within the local limits of which the domestic violence took place. Ensure that the aggrieved person is provided shelter in the shelter home. If she requires, if there is a need, then they will ensure that the aggrieved person is provided a shelter home, and they will also report it to the police station. No suit, prosecution or other legal proceeding shall lie against any service provider or any member of the service provider who is deemed to be acting or purporting to act under this act for anything which is in good faith done or intended to be done in the exercise of powers and discharge of functions under this act. A very important provision, that if you are acting in a bona fide manner in good faith, then you cannot face any kind of prosecution. Duties of government. The central government and the state government shall take all measures to ensure that the provisions of this act are given wide publicity through public media, including television, radio, print media at regular intervals, and now we have social platforms. So there also the government can publicize the different provisions related to Domestic Violence Act. The central government and the state government officers, including the police officers and the members of the judicial services, are given periodic sensitization and awareness training on the issues addressed by this act. This needs a proper training program at all levels so that we are able to address the issues of violence. Effective coordination between the service providers by the concerned ministry and departments dealing with law, home affairs including law and order, health and human resources to address issues of domestic violence is established, and periodical review of the same is conducted. It is very important that you have to review also that there is a coordination between all these departments and they are able to address the issues of domestic violence. So in the end, to conclude, I will just tell you that when we have talked about this legislation of domestic violence, then we have understood the essential definitions. We have also understood that what is the role of the service provider, what is the role of the protection officer, the magistrate, what are the orders which the magistrate can pass for protecting the woman, for ensuring that her dignity rights are not further violated. And we have understood what is a shared household, and we have also understood that it is not important that you cannot file a case after 10 years, 15 years, 20 years of that trauma, that suffering. It is not important that today I have faced domestic violence, I file a case immediately. You can file it even at a later point of time. What makes it relevant is whether you have suffered violence or you have not suffered. So every case, the facts of the case will speak up and will help the judiciary in deciding the case on its merit. Thank you all for listening. Have a good day, and we will continue this legislation in the next session. Thank you.